There is a point in every high-stakes legal proceeding where the carefully maintained architecture of procedural order becomes too fragile to hold the weight of what is actually happening inside it. Most proceedings never reach that point. The lawyers are too disciplined. The stakes are managed carefully enough that the structure survives. What happened between J.D. Vance and Adam Schiff in that courtroom was the moment the structure did not survive. And what came out when it collapsed had been sealed inside redacted documents for long enough that hearing it read aloud in a public proceeding felt to everyone in that room like something that could not be put back. The files had been at the center of the dispute for months before either of them stood in that courtroom. Their existence was known. Their general subject matter was known. What was inside them was not known, because the pages that contained the specific information had been redacted so thoroughly that in certain sections the blacked-out portions outnumbered the visible text by a ratio that made the documents look more like evidence of concealment than evidence of anything else. Schiff had been arguing for the continued sealing of those files since before the proceeding began. His position was built on a framework that combined national security considerations with procedural arguments about the appropriate handling of sensitive materials in an active legal context. The argument was not frivolous. There were genuine reasons why certain categories of information warranted protection from public disclosure during an ongoing proceeding. Schiff had assembled those reasons carefully and presented them in language that gave the court legitimate grounds to maintain the seals. Vance had been opposing that position with equal preparation. His argument was that the redactions had gone beyond the protection of genuinely sensitive material and into the protection of information that was sensitive not for national security reasons, but for political ones. That the files contained documentation of decisions and communications that certain people had powerful incentives to keep from becoming part of the public record, and that the public interest in transparency about those decisions outweighed the arguments being made for continued concealment. The proceeding had been moving through these competing positions for the better part of 2 hours when the dynamic changed. It changed because of something Schiff said. A specific characterization of the redacted material that Vance had been listening to with increasing visible tension for the preceding 30 minutes. Schiff described the censored portions of the files as containing information that had no bearing on the central questions before the court, that the redactions removed material that was tangential, sensitive in ways that had nothing to do with the substance of the dispute. Information that protecting served the integrity of the process rather than obscuring anything relevant to the outcome. Vance had the files in front of him, the unredacted versions, the ones that had been made available to parties in the proceeding under seal. He had been reading them while Schiff was speaking, and what Schiff was describing bore no relationship to what Vance was reading. He said so, not in the measured language of a legal response, in the direct language of someone who has run out of patience for a characterization they believe to be false and has decided that the cost of maintaining procedural composure is higher than the cost of abandoning it. He said that what Schiff had just described as tangential was not tangential, that the redacted portions of the files contained information that was directly relevant to the central questions before the court, that the characterization being offered to justify the seals was not an accurate description of what the seals were actually hiding. Schiff responded immediately. He pushed back with the authority of someone who had spent considerable time in rooms where information was classified and had developed genuine conviction about where the lines should be. He told Vance that the characterization of the files was a matter for the court to determine, that Vance's interpretation of what was relevant was not the standard by which the seals should be evaluated, that the process existed precisely to prevent individual parties from making unilateral decisions about what the public was entitled to know. Vance looked at him, he looked at the files, he looked at the court, and then he started reading. He did not ask for permission. He did not make a procedural motion. He opened the first file to the section that had been redacted, and he began reading the unredacted text aloud, in a voice that was controlled enough to be heard clearly by everyone in that room, and loud enough that there was no possibility of pretending afterward that it had not happened. The first thing he read was a date. then a name, then a description of a communication that had taken place between two offices at a specific moment in a sequence of events that the public version of the record described very differently. It took 11 seconds for Schiff to object. Those 11 seconds were enough. Because what Vance read in those 11 seconds connected two pieces of information that the redactions had been designed to keep separated, information that individually meant relatively little. Together, they told a story about a decision made at a level of government that the public version of these events had never acknowledged. Schiff was on his feet. He was objecting on multiple grounds simultaneously. The court was calling for order. Vance kept reading, not because he had lost control in the sense of being unaware of what he was doing. He had lost control in the specific sense of having decided that the procedural consequences of what he was doing were less important than the informational consequences of stopping. He read through the first objection. He read through the second. He read through the court's initial call for order with the focused momentum of someone who understood that the window for what he was doing was measured in seconds, and that every word he got into the record before that window closed was a word that could not be taken back out of it. The second section he reached was the one that stopped the room in a way that the first section had not, because the second section contained a name that had not appeared anywhere in the public record of this matter, a name attached to a communication that had taken place at a moment when the public account of events said that no such communication had occurred. He read the name. He read the date. He read the first two lines of the communication before the court intervened with enough force to make continuing impossible. The intervention came in the form of a direct instruction that was not a request. It came with the kind of authority that a proceeding carries when the person exercising it has determined that what is happening has crossed from aggressive advocacy into something that threatens the integrity of the process itself. Vance stopped reading. He closed the file. He set it on the table in front of him with the deliberate care of someone placing something in a specific location for a specific reason. And then he looked at Schiff and said one sentence that was not part of any legal argument and was not directed at the court and was not designed to produce a ruling. It was directed at Schiff personally. It described what Vance believed the redactions existed to protect, not in abstract terms. In the specific terms of the name he had just read and the communication that name was attached to, and what that communication revealed about the decisions that had been made, and who had made them, and who had subsequently argued for keeping that information sealed. Schiff did not respond to the sentence immediately. The room did not allow for an immediate response because the room was not quiet enough for a response to be heard. What had been a formal legal proceeding had become something else in the space of approximately 4 minutes. The people in the gallery who had been following the exchange with the concentrated attention of those who understood its significance were no longer quiet. The court was restoring order with an urgency that had not been present at any earlier point in the proceeding. Schiff's response came after order was restored. It was measured in a way that the moment did not make easy. He addressed the court. He argued that what had just occurred was a deliberate violation of the sealing order, that the material read into the record had been read in direct contravention of the court's authority to manage sensitive materials in an active proceeding, that the information now in the public record had been put there through an act that could not be characterized as anything other than intentional. He was right about the intentional part. Vance did not dispute it. When given the opportunity to respond, he said that the intentionality was the point, that a sealing order cannot be used to protect information whose concealment serves the interests of the parties arguing for its concealment, rather than the interests the seal was designed to protect. That the public record now contained what it contained because the alternative was allowing a characterization of those files to stand that he believed was false and that the court had been in the process of accepting. The name that Vance had read was now in the transcript. The date was in the transcript. The first 2 lines of the communication were in the transcript. They could not be removed from the transcript. They could be disputed. They could be contextualized. They could be surrounded by competing interpretations and procedural arguments about how they came to be there and what weight they should be given.